I first want to start by really just thanking you. This has been a long week, and it's a lot of evidence. It's been a lot of evidence. There's been a lot of witnesses, and there's been a lot of courtroom things that are happening. So I just really want to tell you that I really appreciate your time, your attention. This is a really important case for everyone involved. It's an important case for the Banks family, but it's also an important case for my client as well. So the court will instruct you that the important evidence in this case is going to be the records, the testimony, and the law. And it's your job as the jurors to apply what you've heard on this stand to the applicable law and make a ruling in this case. One of the important things that I appreciate about juries is you don't have to leave your common sense at the door. So I'm going to talk a lot about common sense during my arguments today. I really want to talk about what the evidence has been coming from the stand, and I really want you to use your common sense in applying that evidence to this case. So what is this case about? Ms. Banks was pushed out of a second-story apartment window by her boyfriend, Michael Spann. In the ambulance on the way to Grady Memorial Hospital, Ms. Banks had a sudden cardiac arrhythmia. Mr. Kern was monitoring her, he was talking to her, he evaluated her in the ambulance transport on the way to the hospital. What this case has been told to you it is about, which we contend it is not about, that Ms. Banks was not being monitored. I'll go into evidence later about that. That we were not monitoring her oxygen saturation. That Ms. Banks was exhibiting cardiac symptoms when we presented to the scene. That there was the improper use of fentanyl in this case. Or that the use of epinephrine instead of amiodarone was a violation of the standard of care. Plaintiff's burden of proof in this case. Plaintiff must prove that Mr. Kern did not use reasonable care and skill by the greater weight of the evidence. You will get a charge on this, but it is important for you to realize that this cannot be based on hindsight. We cannot go back in time from what we knew at Grady and apply that to what Mr. Kern was presented with. We have to stand in the shoes of Mr. Kern and see what he knew at that time and was his assessment reasonable. Plaintiff must prove that Ms. Banks' death was caused by Mr. Kern's negligence, and not something else. And this cannot be based on speculation or possibility, but it needs to be a medical probability. And this testimony must come from experts. What is the undisputed evidence in this case? Ms. Banks' death was unavoidable, and it was not caused by anything Mr. Kern did or did not do. Ms. Banks suffered a traumatic cardiac arrest. This is what we've seen on the actual autopsy report. And the cause of death was from a fall out of a window. Michael Kern, who we're representing, he had nearly 12 years of combined experience, 9 years as a paramedic. He's certified through the Georgia Paramedic Association. He's gone on to be an instructor for other paramedics. He now serves as a paramedic in Walton County, and he was an EMT and both a paramedic with AMR. I want to go through a couple of the important timelines in this case, but we've all seen the PCR report that will be back with you. But they arrived on the scene at 12:32. They're at the patient's side 13 seconds later, assessing her. And they're transported from the scene at 45:42, 12 minutes later. And we'll talk a little bit about that later. Vital signs that were obtained. We've gone over these vital signs ad nauseum, I feel like, but it's important for us to talk about the fact that she was stable, and these vital signs are indicative of that. You heard that from Dr. Linzer's testimony this morning. These are not vital signs of someone who is going into either cardiac arrest or respiratory arrest. These are stable vital signs. What else is important? Her Glasgow Coma Scale. She's talking, she's alert, she's able to respond to questions. This is not a person that is in respiratory distress and cannot breathe. It is not mentating. A large question that I think you guys are going to have to answer was an initial pulse ox obtained in this case? You've heard argument from plaintiff's counsel that Mr. Kern has made up this value of 99%. And this is when I talk about common sense. I want you all to take a step back. This call to Grady was made before anything happened to Ms. Banks, before her death, before this lawsuit. This was a call that was made contemporaneously with providing care and treatment to Ms. Banks. What reason does Mr. Kern have to lie about an SpO2? We've heard the audio. Did the medic ever ask him what the SpO2 was? That was information that he volunteered. So the argument is that Mr. Kern volunteered a vital sign that was normal in order to get pain medicine. If he wanted to alter or falsify a vital sign, why would he not falsify the respiratory rate? We have heard all week that a respiratory rate of 30 is an abnormal respiratory rate. If he wanted to falsify vital signs in order to get narcotic pain medicine, why would he give the accurate respiratory rate? Does that make sense to you? What does your common sense tell you? You've heard from our experts that this is the appropriate protocol as it relates to a trauma patient. Ms. Banks was a trauma patient. She was appropriately categorized as such. Plaintiff's experts agree that she was a trauma patient. She was appropriately categorized in this section of the document. And so we're really here about whether or not Mr. Kern monitored her SpO2 readings. That is what we're here about. Whether or not after taking that initial SpO2, if he continued to monitor. And the allegation, I guess, also is that he failed to document the initial SpO2 into the medical record. So after this traumatic event where his patient has just coded on him, the fact that he forgot to go back in his document and document an SpO2 that was documented in the field or recorded in the field, that is the criticism against Mr. Kern. And we agree that we did not do continuous monitoring of SpO2. But you've heard from Dr. Linzer today, why did we not do that? You were riding around in the back of an ambulance with something clipped to your finger while someone is moaning and moving around in pain. Is that going to be an accurate assessment of how that patient is doing? No, it's not going to be. What is going to be more accurate is talking to the patient, asking them questions, looking at them, seeing how they're doing. And that's why he used his professional judgment by not getting an SpO2. And the protocols allow for this. You've seen this. The protocols allow for a provider to use their professional judgment based upon the patient that is in front of them. You heard Mr. Burton say he's responded to thousands of calls. He's never responded to one call where someone's been pushed out of a window 11 feet in the air. This is a unique situation where these individuals are responding to the scene, assessing what's going on, and making a best course of action based upon the information that they have at that time. And they're allowed to use their professional judgment in doing that. The SpO2 monitor packet also acknowledges that SpO2s are unreliable. Pulse oximetry is a tool to be used. In addition to patient assessment, care should be taken to assess the patient at all times. Do not rely solely on SpO2 measurements. Why? Because it's known to give false information in situations like this. The autopsy report you'll see. Ms. Banks unfortunately passed away from acute cardiac dysrhythmia complicated from a fall, with other significant conditions being ischemic heart disease and diabetes. So one of the things that I wanted to point out from Dr. Swirsky's testimony is that, as you probably can imagine, plaintiff's case has changed as this case has progressed. You may recall Dr. Swirsky initially testified that AMR was negligent because Kern never gave fentanyl. He never gave fentanyl, he wrote it in the medical record, he's wrong for writing it in the medical record, a medication he never gave, it wasn't found in her bloodstream, therefore Kern is negligent. Also, Brady's negligent. When we affirmatively prove that there actually was fentanyl in her bloodstream, now Dr. Swirsky will say anything. Now he's telling us, oh, now we're negligent for giving fentanyl. And now we're negligent for giving fentanyl because it caused the respiratory depression. And oh, because Grady's not here, Grady's not negligent, and she's dead on arrival. Plaintiff's theories of the case. Ms. Banks did not suffer from trauma and therefore did not need to go to Grady. Does that make sense to you? Someone falling 11 feet, 4 inches from the sky, that she does not need to go to a trauma center?
I object. That is never, when we have ever contended that she didn't need to go to Grady. That's a misstatement of this case.
Okay, counsel, can you rephrase?
Well, can I just respond for, when I questioned Dr. Wright, he actually said that he didn't believe she needed to go to a level 1 trauma center, just a trauma center, so that's why it is evidence in this case.
Okay, if you could just clarify and rephrase.
Yeah, no problem.
Thank you.
She needed to go to level 1 trauma center. Why? Because we don't know what's going to happen to her in the future. All we know is that she fell from a height of 11 feet, 4 inches, and that she needs to be assessed. She could have internal bleeding. She could have delayed presentation of symptoms. She needs to go to Grady. They made that decision to take her there. Mr. Kern took an inadequate medical history. The argument's being made because he didn't document vital signs every 5 minutes, or every 5 minutes, and only did it 10 minutes, that somehow would have changed the outcome of this case, despite the fact that you've seen consistent vital signs every time they've been taken. Mr. Kern should have done a 12 lead instead of a 3 lead EKG. That's been disputed with their experts. Mr. Kern should have continuously monitored oxygen saturation levels. Mr. Kern should have administered epinephrine instead of amiodarone. Ms. Banks' cardiac arrest was not fatal. They are asking you to take a protocol and apply that to every patient. And that is not what paramedics do. And that is not what you want paramedics to do. As we've stated, this case has to be proven through expert witnesses. And we've presented expert witnesses, they've presented expert witnesses. Who did you hear from? Kathleen Quick, who's a nurse. We'll talk about her. Dr. Wright, we'll talk about him. And Dr. Brian Swirsky. We'll also talk about the experts that we brought you. You saw Dr. Swirsky by video. 90% of his testimony is for the plaintiffs. 130 cases in 4 years. He's done more cases than our expert has done in 27 years, in the last 4 years. This is his primary source of income at this point in time. He's not alleging that ventricular fibrillation happened before 1:06. If you recall, what he said is, it happened more likely than not between 1:06 p.m. and 1:08 p.m., which is consistent with what we've been saying. He agrees that Ms. Banks would lose consciousness and stop talking at the onset of ventricular fibrillation. What we have been saying, which is why we believe it's more important to watch the patient and not an SpO2 monitor. Agrees that, well, first I want to point out again, at the start of the case again, he alleged that we gave no fentanyl. Now he's saying we gave her too much, calling her respiratory depression. His opinions have been inconsistent in this case, purely to just make a case against AMR. He agrees that 8 minutes after fentanyl was given at 12:48, her vital signs were normal. What did Dr. Linzer say? When you administer fentanyl, you're going to see a rapid change in someone's vital signs. They're going to have a respiratory depression as a result of being administered fentanyl. Then we had Nurse Kathleen Quick. Not a paramedic, never worked as a paramedic. She does injections in medical sales. This is who they chose to bring to you as it relates to the negligence of Mr. Kern. Her ambulance experience is limited to being a part owner of an ambulance company that does hospital-to-hospital transfers. She agrees that the adult assessment protocol that we've been using is the appropriate protocol in this case. Nurse Quick also gave criticisms against Grady Memorial Hospital. I want to point out, we did not hire Nurse Quick. I've never spoken to Nurse Quick before she was on the stand. They hired Nurse Quick. Those opinions regarding Grady Memorial Hospital were never elicited when they asked her questions. We had to ask her questions. Aren't you critical of another place that provided her care? Why are they not being forthcoming about that? She agreed that Grady was grossly negligent in failing to provide care to Ms. Banks. failed to initiate intubation, failed to administer epinephrine, failed to do several rounds of chest compressions, failed to do vital signs, failed to conduct a sonogram, failed to investigate the reason she went into cardiac arrest. We did not elicit those opinions from Ms. Banks. This was their expert, or Nurse Quick, this was their expert. What I found ironic about the entire situation is they brought in a nurse expert in here to tell you the importance of following rules and protocols when she's been cited this year for not following rules and protocols in her own state. She was cited this year for practicing outside of the scope of medicine. This is the person they chose to bring to you. We heard from Dr. Wright. He's a plaintiff in this case. The bias is there. He's an anesthesiologist. He's never practiced as a paramedic. He's never practiced as a cardiologist. He testified that Mr. Spann did not contribute at all to his mother's death. Is that credible? The man who was there, was not at her bedside or down in the bushes where she was not anywhere to be found, who pushed her out of a second-story window, didn't contribute at all to her death. Is that credible? Has only provided fentanyl in controlled hospital settings. He's not provided it outside in the field. He's providing it to patients who are going to go to sleep for anesthesia purposes. Of course you're going to monitor them in a different way than when you're administering fentanyl to have pain relief. Again, Dr. Wright had criticism against Grady. Those weren't elicited on direct examination, but in cross we had to remind him, your sworn deposition testimony in January of 2020 was that she was not dead on arrival when she presented to Grady Memorial Hospital. And then denied it in court. What changed? The fact that Grady isn't sitting at the table with us. That's what changed. He agreed that Grady failed to initiate intubation, failed to conduct more rounds of epinephrine. He believed that his mother's sternum should have been open to try resuscitation, and that he failed to perform an adequate fluid resuscitation. These were all criticisms that were elicited by not our expert, by Dr. Wright. So who did we choose to bring you? We brought you Dr. Linzer, who you heard from this morning. Dr. Linzer is an emergency medicine physician who has spent over 30 years drafting protocols, procedures for the very state we live in. That is why we chose him to be an expert in this case. We brought you Dr. Charles Wilmer, who works at Piedmont Heart, one of the first individuals who were opening up cath labs at Piedmont Heart Institute. These are the individuals we chose to bring you because we knew that their knowledge and experience were unique to the issues in this case, and we believed you deserved to hear from them. And you'll also hear that Mr. Kern is also able to testify regarding whether or not he complied with the standard of care for paramedics, so he's also an expert for himself. You heard from Dr. Linzer this morning. I'm not going to go over all of it. I know you guys just heard it. But what did he say? Mr. Kern was reasonable in his care and treatment. The man who wrote the protocols, reasonable in his evaluation and care and treatment of Ms. Banks. Paramedic Kern correctly assessed Ms. Banks as a stable trauma patient. You take the entire patient. Did she have a high respiratory rate? Yes. We don't deny that, but why does she have a high respiratory rate? Is it because she's in respiratory distress, or is it because she's in pain? It was because she was in pain. Paramedic Kern was not required to monitor O2 saturations during the trip. Why not? Because they're going to be unreliable. So what did he do? He watched his patient, and that was appropriate. He used his clinical judgment appropriately. Ms. Banks had stable vital signs and was able to communicate throughout the entire trip. She was able to have a Glasgow Coma Scale of 15 right up until the time of that immediate cardiac arrest. And what happened when that happened? Mr. Kern responded like he was supposed to. What I found most compelling about his testimony was that the pulse ox would respond last in that situation. If he was following numbers on a pulse ox, he would have been delayed in responding to this cardiac arrest. So he actually responded timely because he was doing what he was supposed to do, which is monitoring the patient. We also brought you Dr. Wilmer. Dr. Wilmer also testified that Mr. Kern was reasonable in his evaluation, care, and treatment of Ms. Banks. The clinical judgment by Mr. Kern in this situation was not only necessary, but proper. He also testified that amiodarone was the best drug to give her to stabilize her rhythm instead of epinephrine. He told you that if that were to happen to him in his cath lab, that would be his first drug of choice, amiodarone, because it's the appropriate drug to use when a patient is having a cardiac arrhythmia. And she was having a cardiac arrhythmia. And it was a cardiac arrhythmia that they noted at the time, and the appropriate treatment for that was amiodarone, not epinephrine. And that's what Dr. Wilmer said he would have used in that situation. He also testified that Ms. Banks was stable throughout the transport. Not any signs and symptoms of having any cardiac issues or any respiratory issues until they happened, and Mr. Kern appropriately responded. We've talked a little bit about this, but this is why amiodarone is the more appropriate drug of choice for epinephrine. It treats the actual issue that you're trying to fix. Why am I going to give a drug when I know exactly what's causing it? I'm going to give the drug that actually treats the situation. And that's what he did. He said that this was high-level cardiac treatment by Michael Kern. And it was indicative of him not only being attentive to the patient, but also being qualified and astute. Michael Kern properly assessed Ms. Banks as a trauma patient. He used medical judgment, which he is required to do, to determine whether or not a pulse ox was indicated. The blood pressure and heart rate was normal, that we've seen on all of the vital signs until 1:06 a.m. And he immediately and effectively responded to her change in condition. He also testified that he complied with the standard of care. When I judge the credibility of a witness, I think it's important for us to all ask ourselves, what story is someone trying to tell me? This is what has happened during the trial of this case. What story are plaintiffs trying to tell you? They want for you to completely ignore that she was pushed out of a second-story window. They want you to completely ignore that we have audio recordings that document an initial pulse ox. Completely ignore that. They want you to completely ignore that their own standard of care criticism, or standard of care experts, have criticisms against Grady Memorial Hospital. Not us, their experts. They also want you to ignore Ms. Banks' prior medical history. We had to hear that she was not a smoker, that maybe the nicotine in her system on autopsy was secondhand smoke. Look at the autopsy report. She was found with a pack of cigarettes. They want you to believe that she's a picture perfect of cardiac health. This happened 20 years ago. There was nothing wrong with her. On autopsy, high grade, heavily calcified, I'm not going to attempt to pronounce that word, but you guys can read it, with 60 to 75% narrowing identified within all major coronary arteries. That's a blockage. And what did Dr. Wilmer say? That, coupled with her diabetes, coupled with nicotine, made her extremely susceptible to having a traumatic and immediate cardiac arrest like she did. Then we had to hear criticisms that really didn't even matter in this case. We had to hear that Mr. Kern was using unconscious bias. That's insulting to you all as jury people. What information were you presented with that there was an unconscious bias? Mr. Kern removed the cardiac monitor from Ms. Banks' body. Mr. Kern didn't do that. He testified that he was 100% sure that those monitors were still on her. He never took them off. But he took them off and there's no evidence of that? Accusing Mr. Kern of administering etomidate. The ambulance doesn't even carry etomidate. They've never been able to give it. We agree that it's in her system, but instead of acknowledging that there's two individuals that provided her medical care, we're going to choose to blame the ambulance company who doesn't have it on their rig, and not the hospital who carries etomidate. That's what we're going to do. But no, they're only going to present to you. No,
The evidence shows that is absolutely false. There is no etomidate in the Grady records or the crash car records. It's a misstatement of fact. I move to strike it.
Your Honor, it's not a misstatement of fact.
It's your turn.
All they have presented is a crash cart kit. They've not presented anything else as it relates to what medications are available in the hospital as a whole. All they've presented is a crash cart kit. The hospital carries etomidate, and that is true.
That's not in
Mr.
evidence.
Neal, I'm going to allow the attorney to continue her argument. Go ahead.
And we do not dispute,
Overruling that objection.
thank you, and to be clear, we do not dispute that etomidate is not on the crash cart. But are you to believe that etomidate, a common medication that is used to intubate people, is not at a level 1 trauma center? But we have to give it. And at this point in time, I'm going to turn it over to Mr. Huff. I appreciate your attention.
Thank you. Mr. Huff?
May it please the court. Good afternoon. I first want to say, like everybody else has, thank you for your time and attention to this case. I know that it may seem contentious among the lawyers. There have been a lot of objections in this case, and I want y'all to know that on behalf of both parties, the lawyers are trying their best to represent their clients. That includes Mr. Neal, that includes Ms. Barnes and I. We are all doing our best, and if we feel like an objection needs to be made to protect the evidence in this case and to represent our clients, we make it. Here's an important point. Please don't hold that against anyone in this case. There are parties to both cases. There are parties in this case represented by different lawyers. We're all trying to do our best to represent our clients. And so I know we've objected a lot during the course of this case. It's delayed the trial to some extent. I apologize for it. It's in the spirit of representing our clients. I'm going to talk to you a little bit about one of the important elements that the plaintiffs have to prove to you beyond a preponderance of the evidence. So remember, the preponderance of the evidence is the greater weight. So if you think, we know that the evidence kind of went back and forth, and I'm not really sure, I think it's about even, then the plaintiffs, Mr. Neal, hasn't carried his burden. It has to be by the greater weight to prove that. And that includes this. They must prove to you that there was negligence by Mr. Kern that caused Ms. Banks' death. Has to be to a reasonable degree of medical probability. You're not allowed to speculate about that. You're not allowed to think, well, he was in the ambulance, maybe a lot of stuff could have been done differently, and maybe she would have lived if some other stuff had been done differently. You can't do that. That would be speculating in this case. It has to be proven to you. And this is a charge that you're going to have. This is the law of Georgia. The judge has determined this is the law that you're required to follow in this case when it comes to the issue of causation. And it's got some components to it. It's going to be on page 5 of the jury instructions that you're going to receive. But it talks about proximate cause. Proximate cause means that cause, I'll read it just to make sure I get it right, which in the natural and continuous sequence produces an event, and without which cause such event would not have occurred. And ladies and gentlemen, in this case, the proximate cause of Miss Banks' death, based on the evidence, is that she was pushed out a window 11 feet 4 inches high, sustained trauma. That is the event, which in a natural and continuous sequence, that's the cause, which in a natural continuous sequence produced the event, her death. The proximate cause of Miss Banks' death, based on the evidence in this case, is Michael Spann. There can be more than one proximate cause of an event, but if an act or omission of any person not a party to the suit, that's Mr. Spann, was the sole proximate cause of an occurrence, then no act or omission of any party, AMR, could have been a proximate cause. And that's the evidence in this case, ladies and gentlemen. One of the most remarkable things when I talked to my family about the case is when we talk about the case, they always come back to this fact. So you're representing the company that employs the paramedic who was sitting in the ambulance a few feet from Miss Banks during this whole time, monitoring her, responding to her change when she became unconscious to do immediate CPR, and taking her to Grady. And there's a person, Michael Spann, who pushed her out of a second floor window in the middle of the night, and she's laying on the ground, and he's not there. He never came to take care of her. He never checked on her. He wasn't with her at all. 911's called, and that's how Mr. Kern gets there. And then he's the person in the back of the ambulance taking care of Miss Banks as she's going to the hospital. And it's dumbfounding to me how the argument can be made that Mr. Spann has no responsibility for what happened to Miss Banks. He has all the responsibility. And to second guess Mr. Kern's documentation when that doesn't even take place until after all these events happened at Grady and Miss Banks has been pronounced dead, and then criticize him for not writing the portable number that he took on Miss Banks in his patient care record, is ridiculous in the context of this case. It really is. The doctors in this case who came and testified to you, Dr. Linzer, Dr. Wilmer, I'll leave Ms. Swatek out for a minute, but certainly Dr. Linzer, Dr. Wilmer, Miss Banks died from a sudden cardiac arrhythmia called ventricular fibrillation. It happened in the ambulance. It happened at 1:06 a.m. Their cardiology expert, Dr. Swirsky, he's not arguing that it happened before then. He's not arguing that Mr. Kern sat there and watched ventricular fibrillation and watched his patient, Miss Banks, stop breathing or slowly stop breathing. He's not arguing that. The evidence in this case is this was a sudden cardiac arrhythmia. Happens 350,000 times a year. Ms. Swatek, I'll walk you through these real quick before I get back to her. It would make no difference if oxygen saturation monitoring was done in the ambulance. Mr. Kern's care and treatment of Ms. Banks was not the cause of her death. Dr. Wilmer, Mr. Kern did what he was supposed to do. The only way you could have prevented this, the only way, is if she wasn't pushed out the window. That's what proximate cause means. If she hadn't been pushed out the window, she would be alive today. It's that event that is the cause of her death. Ms. Swatek, she testified, she was the video late yesterday. There was fentanyl in Ms. Banks' system. It was in her blood on toxicology along with other things. It was at a low level. And you heard testimony that it was at a level that would not cause somebody to have respiratory depression from the fentanyl. The fentanyl is given at 12:48 a.m. We know what her vital signs are 8 minutes later. They're not any different. We know she has a small amount of fentanyl, but despite all this, the plaintiffs want you to believe that it was fentanyl that caused further respiratory distress. It's just not the evidence in this case. It's not what she testified to. Now, is there a etomidate? Yes. And you may remember this in the opening statement. I told you, I said, there's going to be evidence that she has etomidate in her blood. It's not carried on the ambulance. There's no record of it being given at Grady. We don't know how it got there. Now, that's exactly what the evidence has been. And we've been straight with you the whole time about that. What's the plaintiff's conclusion from the exact same evidence? Oh, Mr. Kern must have given it, even though it's not in the ambulance, because he used this device called an iGlide to try and open her airway. Had to have been him. Who's bringing you the facts and the real story in this case, and who is trying to convince you of a narrative about what happened. Use your common sense when you think about that. The same is true of blaming Grady. You may remember an opening statement, Mr. Neal said, the defense, their experts are going to come in here and blame Grady. And I got up in front of you and said, no, it's not our experts. You're going to hear that.
That's not correct, because their experts did not blame Grady, and I did not say that at all.
Okay.
That's not true at all.
What's your response?
Second time, is closing argument.
Okay, what's your response?
I was going to, all right, my response is, that was Mr. Neal's argument, and my response in the opening statement was, you're going to hear that from the plaintiff's experts.
Okay, I'll let you continue. Counsel, you can continue.
All right, so Mr. Neal said the defense is going to blame Grady, and I came up in front of you in an opening statement and said, you're going to hear that Grady was negligent from the experts the plaintiffs are going to call. And what happened? It was Ms. Quick and Dr. Wright who blamed Grady in this case. Dr. Wilmer didn't have any criticisms of Grady, and neither did Dr. Linzer. So again, who is giving you the story, the whole story in the complete context, and who is trying to make the evidence fit into a certain narrative? Who brought you the facts, not arguments? Who brought you the whole story and not the pieces? In the search for truth, which is what your job is. One more jury charge. This is some more law in this case. It's about impeachment. You all are the experts on the credibility of the witnesses. Your assessment of a witness's credibility may be affected by comparing testimony or statements they made before trial and at trial, and comparing the two. Now, there's been some different kinds of impeachment in this case. True impeachment, for example, was when Ms. Barnes was asking Nurse Quick questions, and she said, no, I had these opinions about Grady before my deposition. And she had to get her deposition out and show that she had those opinions in the deposition after doing 30 plus hours of review under oath at that time. And she was impeached on that. What's not impeachment is for attorneys to say, because attorneys are not, what they say is not evidence, is to say, for example, you never told us that in your deposition. You never said anything about getting a pulse ox in your deposition, did you? That's not impeachment. He tried to impeach Mr. Kern about it. He pulled up some questions about monitoring. But when Mr. Kern was answering those questions, he pointed out, well, I was interrupted. We were talking about monitoring. I agreed she wasn't monitored, but you never asked me if I got a pulse ox when I first came on the scene. And that's the truth. And so to suggest, well, Mr. Kern, made up a story about this, or he's not telling the truth about that, or we had a deposition of him, 2 depositions in fact, where he never said this. That's not true impeachment. It's for you to decide what was the true impeachment in this case. There's a difference between what the use of the depositions by Mr. Neal and the use of the depositions by Ms. Barnes when they disagreed with what somebody said. Ms. Barnes' impeachment was because the witness said something different. Mr. Neal's impeachment was because he didn't like what was being said, and he never called Mr. Kern to a page with a question and answer where there was the specific question, did you get a pulse ox?
That is an absolute misstatement of the facts, and I'm going to go through the transcript of my rebuttal. I asked him several times in the deposition, he denied he ever took a pulse ox. He admitted that he never took a pulse ox.
Got it.
Yes.
That's an improper objection, number one. Number two, we had Mr. Kern on the stand for a lengthy period of time, and it was never shown to him or displayed to him.
Well, we opened the deposition and he had-
Attorneys, we can move on. Thank you.
Y'all heard the evidence in this case. What the lawyers say in argument, even what I'm saying right now, it's not the evidence. The evidence is what you heard from the witness stand. And whether or not somebody was successfully impeached with a statement on point is for you to decide. There's never a point during the trial of this case where Mr. Kern was shown a statement saying, you said you didn't, take the pulse ox. And we know from the audio recording, taken before fentanyl was even given. And by the way, Mr. Kern was not calling for fentanyl, he was just calling for pain medication. He brought up morphine. It was Dr. Matthews on the phone call who said, well, do you carry fentanyl? How about fentanyl? And the plaintiffs want to argue, well, no, he made up 99% so he could get some pain medication for Miss Banks. And that was somehow his motivation in this case. And ladies and gentlemen, again, use your common sense. That phone call is recorded by Grady. It's from the night in question. 99%. One of the things the judge is going to tell you about Mr. Spann, the unavailability of Mr. Spann to testify as a witness in this case, to take the stand, is not for your consideration. On your verdict form, once I finish, I'll sit down and the judge is going to instruct you on the law, and she's going to talk to you a little bit about the verdict form. And this is part of the verdict form on the second page. I'm going to talk about this first, but then go to the first page. But if you find that AMR is at fault, then you will be asked to assign a percentage of fault for AMR, Mr. Spann, Grady Memorial Hospital, and the judge will explain to you that you would put percentages for them if you find that AMR, through Mr. Kern, was negligent and caused the death of Ms. Banks. You only get to that if you find those things first, and this will be easy to see from the verdict form. I wanted to talk about that first, but I want to be clear that what we're asking you to do in this case is find in favor of AMR. Find in favor of the defendant based on the evidence that Mr. Kern was reasonable in his actions in this case, and that Mr. Kern's actions did not cause or contribute to the death of Ms. Banks. She had a fatal ventricular fibrillation. It happened when he was right above her. He saw it immediately, looked on the monitor, and saw ventricular fibrillation. That's undisputed evidence in this case. He began CPR immediately. Undisputed evidence until he could get help. Then he was able to shock her and proceed. Dr. Wilmer told you the gold standard, if somebody has a cardiac arrest and you're by yourself, is to do CPR so that you can circulate the blood. You don't waste time by giving oxygen because it would be hard to get the heart rate back, as Dr. Linzer explained in that graph. It's been a long case, even though it's only day 4, but it seems longer. I'm finished. When I stop talking, I sit down. I'll not get a chance to talk to you again. It's hard to stop talking because I know that when I sit down, Mr. Neal will have the last word in this case before the judge instructs you on the law. And there'll be things said that Ms. Barnes and I will want to respond to, and we're not going to be able to. There's things that we can't predict that are going to be said. I want to be clear about something with respect to Ms. Banks. We've tried to bring you the medical evidence about Ms. Banks. At no point during the trial of this case have we meant to suggest that she's not a great lady, great mother, great grandmother. And I think you can see that in the photographs that you've been shown in this case. And we've never meant to suggest otherwise in this case. Verdict comes from a Latin word which means to speak the truth. We've tried to bring you the truth in this case. We ask that your verdict be in favor of the defendants. There was an article in the Atlanta Journal-Constitution recently in the last 5 years, that had famous quotes by Harper Lee, who was the author who wrote To Kill a Mockingbird, and it had famous quotes, not from that book, but just in general. And one of the things that she was quoted as saying is, the highest tribute you can pay a person is to trust them to do right. And we're paying you the highest tribute in this case by selecting you as jurors and giving you this case to decide based on the evidence and the law, as you heard it. So thank you.